It is a great pleasure to be able to say a few words about our guest of honor, Mr. Moyeenul Islam Chowdhury, Honorable former Justice of the High Court Division of the Supreme Court of Bangladesh. Mr. Chowdhury completed his BA Honours, MA in English and LLB under University of Dhaka. He joined in the judicial service as Assistant Judge in 17th March 1982 and served in the Ministry of Law, Justice and Parliamentary Affairs as Assistant Secretary from 1984 to 1988. He was trained as a legislative draftsman in Dhaka under the Commonwealth Fund for Technical Cooperation of the Commonwealth Secretariat, London, UK in 1984. In due course, he was promoted as District and Session Judge on 1st March 1998. Mr. Chowdhury was elevated as Additional Judge of the High Court Division. Mr. Chowdhury was elevated as Additional Judge of the High Court Division on 23rd August 2024 and appointed as Judge of the same division on 23rd of August 2006. As all good things must come to an end, Mr. Chowdhury, one of the most senior judges of the High Court Division of the Supreme Court, retired from his 38 years of judicial career on January 9, 2020. During his tenure, he was passed several landmark decisions. Presently, Mr. Chowdhury is involved as an arbitrator in a number of local and international arbitrations. Mr. Chowdhury, during his judicial life, participated in international seminars, conferences, workshops in Australia and Thailand, and also participated in sharing of views and experiences with Canadian judges in Ottawa, American judges in Newark, Malaysian judges in Kuala Lumpur, and Filipino judges in Manila. He was also visited India, Saudi Arabia, and United Kingdom. Ladies and gentlemen, put your hands together for Mr. Justice Moyeenul Islam Chowdhury.
Respected guest of honor, Mr. Rahman Hussain Kasim, King's Counsel, distinguished guests, ladies and gentlemen. I deem it a privilege to address this august congregation in this pleasant evening. As you know, law is by nature a mixed concept and has often different and complex philosophies. Yet, law is one of the deepest concerns of the civilized humanity because it offers protection against tyranny and anarchy. But in spite of coexistence of various legal philosophies, the concept of law is more easily understood than defined. Over the years, the legal philosophers have disputed and the lawyers have debated as to the meaning and purpose of law. According to Edmund Burke, law and arbitrary power are in eternal conflict. The purpose of law, as I understand, is the success of justice. Judges are charged with saying what the law means. When they speak, the force behind the law begins to operate. But you see, the judges cannot establish the rule of law single-handed. The other concerned agencies and stakeholders must play their due roles in this regard. Otherwise, establishment of the rule of law will remain a far cry and a piece of music of the distant drum. Anyway, I take this opportunity to say a few words about the bench and the bar. It is often said that the bench and the bar are the two sides of the same coin. They go hand in hand. Both the judges and lawyers are imbued with the same jurisprudential ideas, albeit their roles are different. So in that view of the matter, any propensity of either side to carry its temporary ruffled feelings against the other to an unreasonable length destroys the moral foundation of both institutions. So the judges and the lawyers must be on their guard to see that the moral foundation of the bench and the bar is not destroyed in any manner. You see, our people crave for quick and inexpensive justice, but their craving has largely remained unfulfilled because of the complex, complicated, and cumbersome procedural laws and backlog of cases. Simplification of the procedural laws is the job of the legislature. You know, we have inherited the present judicial system from the British. This Anglo-Saxon judicial system, I must say, has become outdated and outmoded to some extent with the passage of time. So it needs to be overhauled. I think the days are not far off when the lawyers, judges and jurists will sit together and evolve a new mechanism for delivering prompt and cost-effective justice to the litigant people. You see, the confidence of the people in the court depends upon the quality of justice it administers. The higher the quality of justice, the more the confidence of the people in the court. The best judgment of the court is the product of the finest submissions made by the bar. But unfortunately, there has been deterioration all around, affecting the quality of justice. According to the observation of the Indian Supreme Court in S.P. Gupta's case, the lawyers are equal partners with the judges in the administration of justice. So the role of the lawyers in the dispensation of justice is no less important than that of the judges. You see, it is often said that the life of a lawyer is not a bed of roses. If he is successful, it is all bad, it is all roses and no bad. And if he is unsuccessful, it is all bad and no roses. Lord Denning, in his book, The Discipline of Law, has said, books are the tools of trade of a lawyer. So a lawyer must have a rich library of his own, because books are the tools of trade of a lawyer. A judge, you know, must be made of sterner stuff. A judge is a judicial craftsman of this craftsmanship. The best guarantee of justice, impartiality and depth of knowledge of the judge concerned. I have the firm conviction that by dint of his unquestioned, a judge can still command unwavering and unflagging respect from the people in general and the members of the bar in particular. You see, in the day-to-day judicial work, judges are often faced with two self-contradictory, self-defeating, and paradoxical legal dicta. That is to say, justice delayed is justice denied, and justice hurried is justice buried. In my humble view, a fine balance has to be struck between the two, paving the way for dispensation of justice on time. You know, the proverbial delay in the disposal of cases is a matter of concern, no doubt. You see, in Bangladesh, the logjam of cases is a perennial problem. The phenomenal growth of population is primarily responsible for a plethora of cases, thus compounding the judge case ratio is very adverse in Bangladesh. In late 1980s, I was posted as Joint District Judge in Dhaka Judgeship. In those days, I had to work from 9 a.m. to 9 p.m. You see, in all, there are about 1,900. That is to say, 1,900 judges and judicial officers. In Bangladesh, to cope with the huge backlog of 5 billion cases. There is 50 lakh cases, 5 billion cases. Given this scenario, fresh appointments of judges in all courts of the country are an imperative necessity. Precisely speaking, the number of judges must be increased rationally and proportionately in view of the huge workloads in the courts of the country. In our country, judge-initiated mediation is a must for quick disposal of civil cases and appeals. Judges must take the initiative in this respect at pre-trial stage and before commencement of hearing of appeals. In fact, the settlement of court cases through judge-sponsored mediation has helped the courts in tackling the wave of cases and keeping the civil justice delivery system functional and effective both in Malaysia and the Philippines. But in Bangladesh, though mediation is a resounding success in family court cases, it is yet to take firm roots in other civil cases. In order to reduce the backlog of criminal cases, plea bargain mechanism may be introduced in our criminal justice delivery system as in the United States of America. Besides, more offences may be made compoundable under Section 345 of the Code of Criminal Procedure. Over and above, judicial magistrates may be advised to proceed against the complainants and informants of false and frivolous or vexatious cases under Section 250 of the Code of Criminal Procedure. Like Malaysia, we should introduce e-judiciary in Bangladesh. This will enhance transparency, reduce irregularities, and eliminate unnecessary delay in the justice delivery system. A system of continuous and stringent monitoring and supervision of the performances of the judges, judicial magistrates, and court employees must be in place in Bangladesh. With that end in view, some senior judges designated as supervising judges or executive judges may be appointed to monitor the performance of other judges and to see that the court time is fully utilized by them. Our judges have been dispensing justice through litigations over the years. In spite of, many constraints, they have been toiling day in, day out to dispose of the pending cases. I am really proud of them, and I also pay homage to them, because there are you'll see many inadequacies, many loopholes in the judicial system. There is a lack of infrastructural facilities in some districts. Even to my knowledge, 3 judges shared the same ajlash by rotation. You just conceive of this situation where 3 judges share the same court by rotation and try to dispose of cases. These are no doubt hiccups. Ours is a developing country. We have, our resources are limited. There are many constraints. Even then, they are doing a good job by dispensing, justice to the litigant people. Although I am a retired judge, the judiciary is my passion. I always feel happy, energetic, and rejuvenated in the midst of judges and lawyers. Before I wrap up, I express my heartfelt gratitude to Mr. Muhammad Rahman for inviting me and affording me an opportunity to say a few words here. Thank you very much.